Okay, go ahead.
Hi, Amy. Thanks for
Hi.
joining us today. We've been having multiple webinars teaching the residents of the villages and surrounding areas about getting their ducks in a row. And so I'm so grateful to have you today with us in this presentation to talk about the legal papers that people need when they move to Florida, as things change in their medical history or in their family dynamics. And so I'm grateful to you coming to us today on what is it that people need to do when they move to Florida, and what kind of legal papers do they need here if life changes. So thanks for joining us today. I'm looking forward to hearing your presentation and you sharing your wealth of knowledge with us. So Amy, if you want to take it away, go ahead.
Absolutely. Thank you so much, Lisa, for having me on here. And I think it's really important that we're able to do, from the attorney's perspective, but also from the work that you guys do there. And I think we working hand in hand and all of us doing this stuff together just really makes a big difference. And estate planning is so much of so many different things. And the legal aspect of it is only one of the arms of it. And it is very important, but it's also important the work that you do and placing people and us working together. It's just really great. So thank you for having me, and thank you for the work that we've been doing together. So I want to introduce myself. I'm Aimee Occhetti, and I have a very small law firm here. Next slide. It is myself and Brian Laird, and it's nice because we are such a small firm, so you get a lot of hands-on experience from us. I will talk a little bit about Brian, who's not here today. He is a former deputy sheriff in Ocala, so he has a little bit of that criminal law background. And he's been doing family law, which goes a lot and intermixes with estate planning also. And I've been a lawyer for 20 plus years in DC. I moved here because of my parents, they're here. And plus I love Florida. And we were just having a little bit of conversation about how the weather is so wonderful here. So it really beats DC, plus the politics. I'm so glad to be away from those politics. But anyway, so the estate planning is our main thing that we do here. And it's truly what I love doing. I love working with the people here. Next slide, please. So why is estate planning important? And it is so important to really start thinking about, right, when, anytime that you are planning what is going to happen in your future. And in Florida, there's some really great things to do in order to avoid probate. And avoiding probate is what we want to do when we're estate planning. That is one of the main things that we want to do. And it's not for yourself or the couple, it is really for your beneficiaries. And it's, to provide for them so that you don't lose all your money that you worked really hard to. So you want to really make sure that what you worked hard for goes where you want it, the way you want it, and to the people that you want to have your money, not to the state and not to lawyers, quite frankly. And you also want to do the estate planning. A lot of times things happen while you might get sick, or there's some incapacitation or some reason that you're not able to pay for your bills or your house or anything, any of the things that you really need. And you need to have these documents in place so that you can ensure that life still goes on, the payments are still made. So, even if you aren't able to physically or mentally write those checks. Next slide. When I say why isn't estate planning important, it's also important to save as much money as possible on, I was talking about the court costs, attorney's fees, and avoiding probate is so very important. Probate is a process that you have to go through if you have assets, and it's going through this judicial process. And what we want to do is, when we are correctly estate planning, we want to make sure that you don't have to do that. And It is very timely. Some of these probate actions can take 9 to 12 months in Florida. And around the United States, it's pretty close to that also. But it is just so timely, and it's a process that we just want to avoid. And nobody really likes to talk about what's going to happen at death. And once you do these documents, you can actually move forward. You don't have to think about it again, really, unless you have some major life change. You do it once, you're done, and you go on, and your beneficiaries don't have to worry, and the money that you've saved is not going to go to the court. Next slide, please. So there are 4 main documents that is in an estate planning, the whole package. And the first thing that I think is the greatest thing to have is, well, the first thing that we ask you is, do you own a house? So many people say to me, hey, I don't have much. I only have, a couple $100,000 saved, and I've got this house. And I'm like, you have a lot. I mean, this is enough for a trust. And really, even owning a house, even if you have a mortgage on it, depending on the amount that you owe, it's enough you want to avoid probate. You do not want your house to go into that court process once you pass. So that trust is a mechanism. And I hate to say this, but so many people will say, hey, just do a will. A will is going to make sure that your assets go where you want it. And that's not necessarily true. A will does have to go to probate. And if you do have a will is just a document that actually designates where you want things to go. So it has nothing to do with the titling of your assets. So the most important thing is, if you own a house or you have certain assets, you need to put them in this revocable trust. Now, people say, what's the difference between a revocable and irrevocable trust? Because we kind of hear these words, and it's really in that word. Revocable means you can revoke it. And so while you have this trust in place, you are the grantor and you are the trustee at the same time. So you're in charge of this revocable trust until you pass. And if it's a couple, then it becomes irrevocable upon both people passing. So then this mechanism of this revocable trust will allow you to avoid that probate process. So it's a really important thing. And like I said, the first question that I ask people, do you own a house? And if you own a house, therein of itself is probably, and not 100% of the time, but more likely than not, a reason to have this revocable trust in place. So that is very important. Then the next document that you have is called a pour-over will, and it's spelled P-O-U-R, as you see on the screen, because what it actually is, it's not a regular will. It's when you have this trust, then you have this pour-over will, and if there's something that you forgot to title, because the revocable trusts are all about titling correctly. If you forgot to title something, and it will, say it's a bank account that you have somewhere and you forgot to put it in your trust, or you forgot to put a paid on death on that account, then it will pour over into the trust. So it will allow, you still would have to go to probate, but it would be a shortened version of the probate process. So that you always have, I kind of call it an insurance policy as part of your estate planning package. So you hopefully will never have to use that will if you title correctly on all your assets. And then the next document is a power of attorney. And that power of attorney in Florida is a document that is in existence while you're alive. So if there is some kind of incapacitation, and I talked about that a little earlier, where you couldn't actually pay your bills, that document allows somebody to do that for you. The power of attorney is in existence. So once you sign that, the person, whomever you give that power to, does have that ability to handle your finances. So they, it's a thing to have that really ensures that finances are taken care of if there's any reason whatsoever that you can't do it. So that's a very important document to have. Now, it does go away once you pass. Your power of attorney no longer exists, and the trust would come into play at that point, so that your trustee would be handling the financial aspects of that. And then there is the medical directive, and we have two parts in the medical directive. The first part is naming your agent, and the second part is basically saying what you want done. And nowadays, a lot of people, it used to be the case that people would be kept on life support for a very long time. Now it's more common that people don't want the artificial food and artificial hydration. So those are some kind of the things that we would talk about with you and what you want in your medical directive. So those are the four main documents in your estate planning, your whole package. There are some extra documents that are also contained in there. Sometimes people ask about personal property. Personal property in Florida, like we would put at the back of your estate planning package, a personal property memorandum. And that is a document that, say, and I like to use the example here, you've got these fantastic golf clubs, and maybe you don't want it to go through the trust and go to your descendants, but maybe you want it to go to your neighbor who really likes golfing. So you can just write in the back, any of this personal property, I want these golf clubs to go to this person, and you sign it. You never have to go back to the lawyer to make those changes for any personal property items. So those are, that's another document that you have in there. And then you also have a certification of trust, which is a shortened document that certifies the trust, where some of the accounts, things that need to go in your trust. I did talk about the house. I also spoke about your bank accounts. So your bank accounts need to do one of two things. It's a paid on death, or you put it in your revocable trust. You have to do one of those things in order for your bank accounts to avoid probate. So that's an important thing. People sometimes don't think about that. Not a hard thing to do. If you wanted to title it in your trust, you just take a copy of your certification of trust to them, give that to the bank. They see this all the time. So it's not an uncommon thing to do. With your house, putting your house in the trust, not a hard process, but you do usually need an attorney to draw up a quitclaim deed. Next slide, please. A quitclaim deed is a document that normally when you buy a house, you would buy the house in your own name, or if it's a couple, you do it jointly. And so it would just be in your names. What we do with it, once you have a revocable trust, we would do a quitclaim deed, which is very simple. It takes the name of the house and moves it into the trust. And so once that's done, it gets recorded with the county, and then you have funded your trust with the house. So that's a very important thing to do. Also, for example, when I moved here to the Villages, I bought my house in the name of the trust. So once you have a trust, if you're going to buy and sell a house, they call it the rule of three here in the Villages. You buy one house, you're going to buy a second or a third. So sometimes people think they're not going to do that, but they do. Once you have that trust in place, you never have to do a quitclaim deed again. You are, again, the grantor and the trustee of your trust. So you do everything as normal. So you would just buy your next house in your trust. So you would never have to do that quitclaim deed again. Some other assets that that need to be titled correctly are stocks, bonds, and I already spoke about the bank accounts, but stocks are an important thing. A lot of people have brokerage accounts, and usually, as I talked about, That certification of trust is something that you would give to your financial advisor or any company that you use to do your finances. And they do know the tax consequences, and they know what assets actually need to go into the trust in order to avoid probate. And I say that because a lot of people diversify and have they may have a brokerage account with some stocks, they might have an IRA or a pension plan or some type of other asset is the case, then that will already avoid probate. So always remember that any asset with a beneficiary will already avoid probate. So the things that won't, again, are these stocks, the bank accounts in your house. Those are kind of the three main assets that I think are important to in deciding whether or not you need that revocable trust. Next slide, please. So like I said, very, very important to avoid probate. And on this slide, you can see these are statutory attorney fees which basically means that they're allowed to be charged by the attorney. So that doesn't account for how much you have to pay for filing a probate action. Filing a probate action in Florida is approximately $400. So, and then that is additional expense on top of the attorney's fees. And then there are other necessary services that you have to do in a probate action, which is notifying creditors. And notifying creditors requires you to put an ad in the paper. Putting an ad in the paper does cost money. So that is another expense that you would have. But for example, if your entire estate is $40,000, the attorney's fees alone that are allowed by statute are $1,500. And then I've got on there plus admin for, the other charges, expenses that will occur paying for the probate action and any other necessary thing that you have to do. And then I just basically give some examples. If your state is 1 to 3 million, it allows 2.5%, which equals 25,000 to 75,000. If your estate is 3 to 5 million, it's 2%, and that's 60,000 to 100,000. So those are just some examples of the amount. This is the statutory limit that can be charged, but you can see as the state gets greater, the percentage gets lower. However, it's still more money. And so it can get very, very costly. It is work. So a probate action, I will tell you, attorneys can charge money because there is a lot of work involved, much more so than doing an estate plan in the beginning instead of having to go through that. Now, our estate planning package, and I put that on there to give you an example of, we're from $1,250 to $1,800. Now, that's just a general amount. If there are certain documents that you need, being in Florida, people are always moving here. So there are times when people come and, we do free consultations to review any documents that are from out of state. And I will tell you, it's not an absolute that you need new documents. A lot of times it makes sense, but it is a case-by-case decision. For us, we will look at it and give you an honest opinion of whether or not you need all new documents, or if you just need a few done, or if you need an amendment, quite frankly. Sometimes we end up doing an amendment because we think that nothing's ever going to change, but life changes, things happen, and sometimes we want to alter our documents anyway. And if you have a trust, we can always just amend that, which is a lot less money than doing a full trust. So that's some of the comparisons if you were to, and again, avoiding probate is not about you or your spouse. It is about your beneficiaries. And it's about the money that you worked hard for. That's it. I have so many people who come to me and they go, I don't care, I'm going to spend every last dime. Well, you are if you plan correctly, but sometimes accidents happen. So it's just, you really have to weigh it and think of the consequences and the decisions that you make. And it just depends on the person and or the couple and how you want to proceed forward with your planning process. Next slide, please. So I've got just two examples here of some, why we want to avoid probate, things that have happened recently that just make me really, really want to emphasize why it's so important to do this planning. And we had a client who he had parents that had done they had a revocable trust, and they had done it years ago, and the wife passed, and the husband sold the house and moved into assisted living. So the house, the proceeds that he had from the house went into his brokerage account, and that's all he had was this brokerage account. He didn't have an IRA or life insurance or some type of already asset that already had beneficiaries in there. And so all this money went into his brokerage account, and he passed, and there was nothing titled in the trust. And because of that, he had $1.3 million. And because of that, the son had to go to probate. And it's a terrible story because this person actually did the whole estate planning. He and his wife did the estate planning correctly. And, we didn't do the estate documents. Someone else did, but, I don't know whose fault it was or what. Maybe it's just not understanding. It's hard to remember what your lawyers tell you to do. So, and you're just not thinking about that as life, proceeds forward and things happen that are unfortunate. So, it's just it was bad because it took a year for the it was $1.3 million. So it was a lot of money that was tied up that could have gone to the kids right away, whereas they had to go through this probate action. And as you saw in that prior screen, that allowed the attorneys, us to charge a great, those amounts were a statutory limit. Attorneys can do less than that, and we did do that. We did a flat fee instead of basing it on the amount of money. We just kind of looked at how much time it would take us. But it's really sad when something like that could have been avoided. I mean, if he had just titled that brokerage account, I mean, it would have taken giving the certification of trust to the financial advisor and putting that in the name of the trust. Really simple thing, and to cost a lot of money and a lot of headache. Because you have to, in this probate action, you got to go tell the creditors, hey, there's all these assets out there that you can tap into if there's money owed. So, those are some things that you really want to avoid. And then we recently had a couple who had been together for 15 years, and we were referred to him and did a house visit. He was pretty sick and was on oxygen, so he couldn't really leave the house, but he had been with the girlfriend for 15 years. He owned the house. It was clear they had a good relationship. She had quit her job to take care of him for the last year. And, he told us everything that he wanted. He had kids from a prior marriage, and he wanted her to have the house. And literally we did the documents a couple of days later, sent the documents over for them to review, and we were going to sign. I mean, we were going really fast because of his illness. And the day that we sent the documents over, I got a call an hour later that he had passed. And the problem with that was the girlfriend, who it was clear to me there was no undue influence, that he really wanted her to have the house, and they had a long-standing relationship. But I mean, they had paid for their documents, and then here they are going to have to go. He had a will, but it was a will that would not be accepted by the courts, which means it wasn't executed correctly. There weren't witnesses on there. It is what he wanted because he told us that, but that doesn't matter. It was not something that could be submitted to the court. Now, the end of the story is good because actually the kids, they had to hire us for the probate action, and the kids wanted her to have the house. So it did end in a very good, a good way, but we just didn't know. And even when she first told us, I mean, it was, you just don't know if the kids wanted the proceeds of the house, and they ended up not wanting it, and that worked out just fine. But it was something where you just go, oh my goodness, this should have happened, if this could have just happened sooner. So anyway, those are some things that that we see, and we just really like to emphasize and educate people about how important it is to do these estate planning documents. And like I said, hopefully you do them once and you never have to do them again. You don't really have to think about it once you've done it and everything. So it's really very important to do. So anyway, I want to, that's all I have. And I know some people may have some questions, so I'll turn that over to you, Lisa.
Great. So I do have some questions for you. Can you hear me okay?
I can hear you fine.
Great. Okay, so I have many families that I work with that are coming from out of state. How soon after they arrive here do you advise people to have someone review their legal documents from another state if they're going to be a permanent resident here in Florida?
Yeah, so I mean, there are a couple of things I've had, and one of the reasons I like to educate people is, even if somebody were buying a house here, I could save them some money from, if we do the documents, even do them over the telephone right away, or you can do everything on the computer now. So if people sent them to me, I could review them on just via email and do that and save them a couple $100, not having to do a quit claim deed if they're buying a house. So I would say the sooner the better, for sure. But if you wanted to save a little bit of money and you're buying a house, get the revocable trust done and buy your house in the trust. That would save you a few $100s. And
that's a really good idea. I never thought about that. So really, when you're coming down here, it's good to meet with an attorney almost prior to purchasing the house, because you want it to be set up in Florida under that family trust, right? And I came down here and my husband had a medical event, and suddenly I'm going, oh my gosh, my documents that I did in Ohio 20 years ago don't work anymore, right? So I was scrambling to change things because I was having a medical event in the family and needed to also begin to put everything in there in Florida, under the Florida legal system. So, okay, that's good to know. That's something to advise people as people are thinking about purchasing a house or a second house. Okay, another question I have is sometimes people have multiple homes, right? I work with a lot of families that are snowbirds, right? So they come down here. Is it okay to have legal documents in 2 different states? Because a lot of people are buying a house here and then they know maybe he's retired, he's going to come down here, and she's behind for 6 months to a year because she's finishing up her career. How do you propose people navigate that step?
So, I mean, again, it's a case-by-case scenario, but I would say if they are eventually going to be located here and they do a trust here, we do quitclaim deeds in other states. We do it all the time, like you said. I mean, we always have snowbirds. Lots of people keep a house up north. So when I say case-by-case, I would ask you, do you think that your spouse is going to keep, or you and your spouse going to keep that house for 6 months or a year? Like, when are you going to put that on the market? Are you never going to put it on the market? If you're not going to ever put it on the market, then I would say it would be good to put that document into the trust, whether you have a Ohio trust or a Florida trust. I mean, I would put that house in the trust. If you're getting ready to sell it in 6 months, and depending on the market, you got to look at all those factors. I've got some clients now that one she's moved down here permanently, but has a Michigan house, and the Michigan house has been on the market now for, I don't know, 7-ish months. So after it didn't sell right away, she was like, hey, can you put this in the trust just in case? So it's really, like I said, it's a case-by-case thing, but eventually you want to have if you have a home, you should, or 2 homes or 3 homes, those should all be in the trust.
Yep. Thank you for that. I have another question. Sometimes, people are thinking I might need a guardian. I have no one, right? Sometimes the people that I work with, they never got married or their spouse died, they didn't have children. Can you kind of speak to that a little bit? Do you ever act as a guardian, or do you have people that you could appoint as a guardian?
Sure. We could do any of that, but I would say, generally speak, I mean, we would call it a trustee most of the time,
Mhm.
for the trust. So, for example, I have a client and somebody that hopefully is your client also, who he's 89, he's in my church, and he has brothers and sisters who are his age, no kids, no spouse, and he needed somebody he could trust. And so one of the roles that we can take on is to be the trustee of the trust. And it's really about whether or not they trust you. People have to feel good that they're in good hands, and things will be taken care of according to what they would want done. So we can act as a trustee. There are corporate trustees that can be in place. Corporate trustees tend to require a amount of your estate in order to manage it. There is a fee when you act as a trustee, but in Florida it's called, quote, reasonable fee. But I would say the standard is somewhere around 1.5% of your entire estate. So it's not a huge amount of money, but I think the most important thing is to really trust somebody. And that goes for, like you were asking about, a guardian. Of course, we could help with that. We sometimes, do the court papers for a guardian, for somebody else. So yeah, we can do that too. But if it's in the trust in your estate planning documents, it would be to be the trustee.
So sometimes people come to me and say, hey, I'm thinking about just going to Staples or Zoom online and pulling some documents and using those as my legal documents. There are a lot of pitfalls to doing that, isn't there?
Don't do that. Don't do that. So
Right.
many
So can you speak on that? Because sometimes they think that this is a great idea, right? And they're just running around, hey, I got this letter. I'm just going to have somebody go notarize this and this will be it, right? Can you speak to the pitfalls of that and how that might not really keep you as safe as you need to be?
Yeah, so don't ever don't do that. I have had some people who have done a pretty good job on that. I can't say it is always terrible, but for the most part, mistakes are made, things are left out, and it's that one time where you did something because you just followed an online form. I mean, they're online, they're free for a reason, or really low price. So I do see a lot of times there are problems with how many witnesses you have. I mean, every state has different laws, and they're small and silly sometimes, but they are the laws. They're what's on the books, and you really need to conform to that. I gave that example in my presentation where I had a person who did a will on his own. He didn't use LegalZoom, but he did go online and looked at something. I don't know where he got it from, and he didn't know, but it was something we couldn't submit. I mean, it just would not be accepted by the court. So it's always best and to get a lawyer to look at it. I will say I did estate planning up north, and the difference in prices, and a lot of it goes to with supply and demand. I mean, there are people here who are looking for estate planning because people come here to retire. So the prices are just, I mean, I'm not going to say they're low because they're not so low, but they're lower than just about anywhere in the country here. I charge 4 times what I do here, up north, and that was the going rate. That's just the way it is, and it's one of those things that it's really worth doing, and you save money in the long run, even if it seems like it's a cost up front. It's really best to do those Zoom. I mean, the LegalZoom. I've just seen so many problems, and
Mhm.
it really costs you way more in the end. And even if you did it, you can always we can review stuff and correct things. I mean, if you want to cut costs like that too.
Yeah, one of the things that I ask families is how recently have they reviewed their documents? I know laws changed 7 years ago with some of the wording or verbiage. And so how often do you suggest people actually have their lawyer review documents that they created in the past? So let's say, for instance, someone moved down here 15, 20 years ago. They did their legal papers. How often do you suggest somebody have them reviewed?
I don't know if I would say an exact, I mean, to really be on the safe side, I mean, I think you'd be okay every couple of years. Um, the laws don't tend to change so dramatically. I mean, I think the biggest thing that was done was when Florida revamped the trust code several years ago, which is what I think you're referring
Mhm.
to. So I think that that was one of the bigger ones. There are times when there are smaller things that occurred, but most of the time it's not going to greatly affect everything. But I do think it's important to get your documents reviewed, and it's I hate to tell people that because I always say, like, you once you do your documents, you don't have to do them again unless there's some really change. I mean, mostly a medical directive is going to be okay with the way it is. It's more important is this the person who executed it, and so
Right.
forth. So I think those are more important. But it really depends on the person. If you wanted to, I try to do something with all of our clients. Well, before this COVID thing, we would do a kind of a happy hour annual event where we'd invite all of our clients, because people kind of they unless they're using us for something like um, contracts or real estate or something that is occurring frequently. When you do estate planning, you don't see your clients so much. And so I like to remind people that, hey, we're still here. If you need to get us to review it, we're more than happy to do it. We do free consultations. So, I mean, even reviewing, if we didn't really have to do anything, we wouldn't charge, for that. But so I really think it depends on the person. If you really want to, if somebody is really like, hey, I want to make sure my documents are 100% correct all the time, you might want to do every 1 to 2 years. I
Yep.
think the most important thing is if you have real changes um, in your family and so forth. Because a
Some,
revocable trust, if you do that, I mean, you're really going to be okay with that.
right.
Really, as because you
Well,
don't
the
have to go to
biggest thing
court for
too I see is that a couple came down here living together. Wife's diagnosed with Parkinson's, husband has Alzheimer's, right? So
that.
all of a sudden, the people that you thought were going to navigate for you may be changing in the ability to manage your estate or even pay bills or to navigate for you medically. And so you have to look and see, are those children or those grandchildren that you thought were going to be able to step up or didn't even think they were on the radar 20 years ago, have those grandchildren now become adults and maybe they're the ones that are going to be navigating for you, right? So sometimes when you have a health change, it's good to have those documents looked at. If somebody wanted to see you, Aimee, what's your are you able to see somebody in a couple weeks, a couple months? What's your time? If somebody called the office today and said, hey, I really never got my paperwork done, or wondering when you can meet with me, when can they do that? Are you setting appointments now?
Um, if you called me today and you said you needed to get in, I would get you in tomorrow. I mean,
Okay.
that's how, I've been a lawyer for 20 some years, and I came from Washington, D.C. So there, we were all workaholics. But I'd really like to do something different than the typical attorney. You will be able to get me on the phone. Brian is a little bit younger than me, so he doesn't like using the phone as much. Um, but I come from that, pick up the phone and talk to somebody. So I answer my phone as much as I possibly can. And, I want to be helpful, and I want, people to know that we are here for them, and we will move quickly. You will not have to sit a long time with us. That is for sure.
That's great to know. So responsive, that's really great. I think we have a few questions, so I'm not going to monopolize the time. We have some people that would like to ask some questions. So is there anybody here that has some specific questions? So I think Luann asked a question. Does she want to ask it, or Luann?
Yes. So I have an irrevocable trust in New York State and bought a home in the Villages. So while I was down there last, I quickly looked into it because I was only down there for a short time, and we did a ladybird deed.
Mm-hmm.
But I'm still kind of confused about having this trust in New York. I still have my home in New York. And I'd love to, come in and meet with you to further discuss this. But if there's any general information that you can give me about already having an established trust in another state, and then having a house in Florida as well.
Yeah, so I definitely would want to look at your documents, and it's hard for me to just say. I very rarely will just give you a blank, like I'll do the general information. Ladybird deed could have been fine for your situation, but I'd have to look at that irrevocable trust. I just had one. We just did one somewhat recently. There was a glitch in that irrevocable trust, so we ended up doing a revocable trust here, and it was an out-of-state one. But it really, I just can't blanket give you the answer. Would love for you. Are you in the Villages now?
I will be down again in November. I did the ladybird deed just as you're talking. Things do happen, and I felt, well, I'm traveling, and what if God forbid something happens to me? This house is just sitting there with nothing protecting it. So that was the quickest option for me at the time, to just know that that house wouldn't have to go into probate.
Yeah. So if you wanted, even before you get down here, but I would definitely recommend setting something up with us and come and meet with us. But if you wanted me to, I think at the end, Lisa's going to give you the email for me. If you wanted to shoot your address down here to me, I can look up and check your deed out before you even get here.
Okay, great. Sounds great. Thank you so much. I really enjoyed this.
Thank you. I appreciate that.
Very informative.
Thank you. Thank you.
Does anybody else have any questions?
I see a finger.
Is that you? Is that Alexa trying to get on? Paul, can you shut the door? I'm on a conference call. Sorry.
Can you hear me?
I have a question. Can you hear me?
Okay.
I have a question.
Okay.
She keeps talking about a revocable trust. You don't want to have a revocable trust. You want to have it irrevocable. Is that correct?
No, they're kind of two different. An irrevocable, you can't ever change. And what used to be the case was people said that it used to be the case that you would set that up to prevent creditors from being able to get at your assets. The laws have changed, and those laws do change on a regular basis, as we all know, tax consequences and that type of thing. And those tend to change in the federal government with the politics. And so they've kind of gotten away to where you can just protect all your assets and nobody can get at them. A revocable trust does not make sure everybody can't get to it ensures that your assets don't have to go through probate. So it's kind of a different arm of that aspect of estate planning. I have seen, and it goes back to what Luann said. I said things change. People say that, I'm never going to remarry. People remarry. There are so many, we all have changes. We go through changes. It just happens. And I had these two people were married in New Jersey. They each had a spouse. Both the spouses passed. They moved here, and I think they kept a house in New Jersey. Her husband wanted to protect all his assets, and a lot of money. They had a lot of money. So I get why they wanted to protect the assets. But she told me she had spent up until that point because of the irrevocable trust, $70,000 on her attorney there, and not being able to get to certain things. So I'm not a big advocate of that, because I do believe that changes happen. And that it's just not, to me, the way to go. And, people live longer than they think. They probably thought, oh, well, this is going to protect our assets for 10 years. And, 20 years down the line, she's still alive and she's fine. Now she's remarried. So, there are just some things that happen. So we have done irrevocable trust, and there are certain instances I won't go into when they make sense to do, but they're not very, not very often do we recommend that.
Amy, can anybody contest the revocable trust
Well, no.
once you pass?
The will is really the thing that can, no, you're avoiding probate by doing that, unless there's some kind of asset that you did not title correctly. And that's why the titling is important, but it is a much better way to go. A will is so easy to contest. But a trust, it'd really have to be a contract type of issue that you would have to win. So it's a totally different type of legal suit. That's the reason you do it. You do it so that you're not going through, if you've got a good trustee set up there who's going to come in and just do what you want, that's the beauty of it.
And I have just one quick question with something you said before. When you spoke about the gentleman who he lost his wife, he sold his house, he put the money in a brokerage account, and he went to an assisted living. And then he passed away before he did any change into his trust, and his son, had a problem, had to go through probate. If he would have made the son a beneficiary to that brokerage account, he wouldn't have had a problem, right?
Well, first of all, Karen, you get an A+ because you really paid attention to my scenario. You did a good job. I have to say that when people actually read their legal documents that we draft for them, I'm like, oh my gosh, that's great, A+. So yes, you get an A+ on that. So the answer to that is the son was a beneficiary to the trust, but on the asset, if a lot of times stocks that are in a brokerage account don't allow you to have beneficiaries attached. So in the financial world, it's qualified versus non-qualified plans. So anything, and I'll kind of simplify it. If you have an IRA or a life insurance policy or a 401k, something
annuity,
annuity. If your annuity has a beneficiary on there, then that is fine. It will avoid probate. Yes. So where people get stuck in this particular instance, he didn't have those. It was one brokerage account, and all he needed to do was to give them that certification of the trust, which he had in his possession. And shame on his financial advisor also for never asking. But like I said, it's hard to determine like who really, it could have just been an accident by everybody kind of dropped the ball type of thing. And no fault to anybody, but the annuity should be okay if it has beneficiaries. When I sit down with people and go through doing the estate planning process, the thing that we tell people is to make sure while you're doing this estate planning, make sure you've got all your ducks in a row. This is my life insurance policy by this person. This is all of my assets that I have, and then we talk about giving a certification of trust to your financial advisor. And sometimes people have certain products here and certain products there. So you just want to make sure that you dot all your I's, cross all your T's, make sure that everybody you're dealing with has a copy of that certification of trust.
And do you give the amounts that these things are worth?
No. That doesn't go in your trust. It doesn't.
That changes.
Yes, but it won't affect your trust. It will. That is just all within your financial institution that you're using to do your assets. That's not anything that needs to change with your trust.
Thank you very much.
Welcome.
Enjoyed it.
Thank you. I appreciate that.
Well, thank you so much for all the information. I'd love to go into when you plan for perhaps incapacity of a spouse or a parent at some time in the future, because I think that sometimes that comes up. I've had many people say, oh, my husband's been deemed he has Alzheimer's disease, and I'm thinking of doing a irrevocable trust and pulling all the assets out of his name, and I'm going to give it all to my children, right? I'm going to put in my children's name. Well, sometimes that spouse does pass away, and now the children say, well, the house is all mine, right? Because my parent deemed me the executor of the will, and I now own the home, and I don't want to pay for assisted living or independent living or memory care for the spouse that's left, my parent that's been left behind, right? So you need to be very careful that the children, sometimes when you're doing that irrevocable trust, understand that this money is not really theirs. It really is that person, your parents' money, right? And I've had this happen many times. I want to speak on that maybe next time that we could have you in, because I think people need to be very careful about creating that irrevocable trust. And sometimes they get forced into it because of someone, their spouse may have cognitive impairment, and it's a little fuzzy. Because you really got to be very, very careful. I had a family, I'll just tell you a quick story. I had a family whose a friend of mine's parents were in New York. He had dementia, went into a long-term care facility, ended up passing away, but they had done an irrevocable trust. Well, the wife lived 20 more years, wanted to move down to Florida, and because her money was in an irrevocable trust, she didn't have the ability to sell her house in in New York. And the only thing she could do, she couldn't even get the cash out of that house. She had to buy another house. She said, well, maybe I want to move to an assisted living or independent living. And they said, no, the money is in an irrevocable trust. The only thing you could do is to buy another house. And she didn't really want to buy another house. She wanted to move into independent living. So sometimes it gets kind of screwy, and you have to be really careful what you can and can't do with that irrevocable trust.
Yeah, I totally agree. I mean, it's a real big problem.
Yep.
A
lot of people here want to sell you that prepaid Medicaid planning, and 99% of the people here are never going to qualify for Medicaid. And nor do they need it, and nor do they need to spend $5,000, $6,000, $7,000 on those documents, because they really don't need them.
Hey, Lisa, we have another question from somebody in Alexa.
Oh, yeah, I see. Alexa? Is Alexa there? Do you want to unmute yourself? Oh,
She's unmuted.
there you are.
How do
Go ahead.
taxes come into this with the IRAs and brokerage accounts and savings accounts?
Can you repeat your question, sir? We didn't hear the beginning.
What are the taxes on the IRAs, which had non-tax money put into it, and stock accounts and savings accounts to the beneficiary or whoever it goes to?
So I'm not sure I'm following your question. What are the taxes? I mean,
Yes.
if you in any type of asset, I mean, I'm not an accountant and I don't do that type of law either, but I mean, you realize whatever gains you realize, you're going to have to pay taxes on. I know one of the newer laws, it's called the Secure Act. Actually, it used to be RMDs. You could do an inherited IRA where you pass along to your beneficiaries, and they can leave the money in the IRA and not have those tax consequences, but except for the RMDs. And I know that now in 10 years, you have to deplete that. That is a newer law that was passed with probably a year ago. So now in 10 years, you have to deplete the IRA, the beneficiaries do. So you pay your gains on that. They will.
I wasn't sure if he was asking the question what does his heirs have to pay? What taxes would his heirs have to pay on his estate? Is that your question, sir?
Yes,
Okay.
Yes.
yes,
Okay. Do you have a
Yes.
financial advisor?
no,
Okay. Well, one of the things you probably want to do is work with a financial, do you have an accountant that does your taxes?
no, I do my own taxes.
Okay, so at this stage of the game, I suggest you look for, and again, if you need some help with someone looking over your financial situation and making sure that, again, Aimee can help with the legal part, but you want to make sure that your full estate gets brought to your heirs at the time of your death and that they mitigate the most amount of taxes. Is that what you're talking about?
Yes, I like that.
Yeah, okay, so we need to get him involved with a wealth manager probably, right? Is that what you're thinking, Aimee?
Yeah, definitely.
Yeah, so wealth manager can again make sure that everything's listed correctly with Aimee or with your lawyer, but also that you have it going the right direction at the time of your death, because there are things you probably maybe need to retitle, or you need to know in advance, or you need to be taking certain disbursements. Sometimes I work with financial advisors too to say, which of these accounts do we need to tap into first in order to mitigate taxes, right? So if somebody suddenly needs care, which of these accounts do we start to use first, because there's money in all different buckets? Yeah, okay, so we need to get Alexa involved with a financial planner probably.
And I can help with any of that also if you want to contact us. We have
Okay,
a bunch of different ones we work with too.
great, okay, yep, we'll definitely do that. All right, are there any other questions? Has this been helpful for people?
Yes,
Good, okay,
I have a question.
okay, go ahead.
Is there a way to provide for a pet if there's no one to care for it? Is there a way to set something up?
Yes.
Are there retirement places for kitties?
I'm a cat lover too. I have a Sinatra is my cat's name. But yeah, you can do something like that in your trust. We could talk about a couple of different things that you can do. But yes,
Good.
people do that. So just you're in good company.
I'm worried about that. Thank you very much.
You're welcome.
I have a question.
Go ahead.
Yes, this is Karen. Not Karen's iPad, but the other Karen.
Oh.
I had a little confusion over the definitions. Is a revocable trust the same thing as a living will?
Yes, it's an interchangeable type of yes.
Okay. And then the medical directive, does that include the healthcare agent that you made?
Yes.
Okay.
Ours does. And like kind of like what you were saying, I mean, there are interchangeable words. I mean, it used to be the case that people would say you have an executor of a will. Now it's a personal representative.
Oh, okay.
They serve the same purposes, but our medical directive does have two parts, which is an agent and what you would like done.
Okay. So power of attorney, is that the same thing as a durable power of attorney?
Correct.
Okay.
Well, there are two types, but the durable is what
What you
use.
use.
Yeah.
Okay, and I missed the beginning, but are you elder care law?
It depends on what you would need, but we don't do Medicare. There are firms that do that in their practice, but we don't.
Okay, but you cover other issues with elders.
Yeah, it would depend on what it was, but yes.
Okay.
You can
All
always give me a call. We can chat about it on the telephone. You can email me. You'll get a response, and we can.
And what's your phone number, Aimee?
I think, Lisa, are you going to put that up, or do you want? Okay.
Here it is.
Great.
So go ahead and take out your phone and take a picture. There you go.
That's a good idea. Thank you.
You're welcome.
So go
Okay.
ahead, Amy, let people know about how they can contact you.
Let them know.
Yep, go ahead.
Oh yeah, so yeah, this is where we're located. If you're in or around the villages, we're near Brownwood. It's a new plaza called Freedom Plaza. It's right down from the new hospital, Brownwood Spa Hotel. And there's the phone number 352-633-9791. You will almost always get me on the phone if you call, and we always respond to our emails also. So the emails are on there.
Thank you, Amy.
All right.
It's been very informative.
Great.
So again, my name is Lisa Honka, and I have a company called Your Key to Senior Living Options. These are some of the events that we have coming up. Understanding Viatical and Life Settlements with Susan Wolf. TLC, which is Transitional Life Counselors, will be doing a presentation on September 24th. And we'll be sending out emails on this, so if anybody's interested, you could sign up for the different topics that we have. Jackie Coons from the Alzheimer's Family Organization will be doing a seminar on understanding the signs and symptoms of dementia. And then we're going to be doing a 6-week caregiver seminar with the Savvy Caregiver. So what we're going to be learning about is caregiving techniques if you are caring for someone who has memory loss. And we're also going to be working on events with Stephen Waterhouse, who is with the Alzheimer's Association. So always look for our emails that come on our newsletter for upcoming events. If you have anything that you're looking for, some topics or some experts on, we'd be happy to find some experts in the area that can help us on this. My company helps seniors find independent assisted memory care communities free of charge. I've helped over 1,000 families in the last 4 years that I have had my company. I work to find, again, in-home solutions. If somebody is looking to find hospice information, or again, just companion homemakers, I have resources to help people. But if they need to transition to a more supportive environment through independent, assisted, or memory care, I work with over 60 communities and about 300 different referral sources know who I am. So I'm happy to just answer questions if you know of a neighbor or a friend who may need my support or services, or if you have some questions regarding what's out there for next steps. Again, thanks everybody for joining us. I hope you have a safe week. And if you have any questions, certainly send me an email. And we look forward to hearing your comments on how this presentation was and if it met your needs. So, all right, we hope you're all well. Thanks again for joining us. Be safe. Bye-bye.